I've owned that land for as long as I can remember. 3,500 acres of rolling pasture, oak-lined creeks, and fence lines my grandfather hammered in by hand. The farm wasn't just property, it was inheritance, livelihood, and history layered into the soil. We leased grazing rights, held mineral rights, and paid taxes on every inch, every year. The nearest neighborhood sat miles away, a polished luxury development that arrived decades later with manicured lawns and a shiny new homeowners association. They waved politely when they moved in. No one ever mentioned authority over my land, because there was none. That changed the morning 2 unmarked trucks pulled onto the south pasture. Men in neon vests started planting stakes like they owned the place. When I asked what they were doing, one of them handed me a folded map and said, almost apologetically, HOA survey. Land transfer finalized last month. I laughed. Then I saw the county stamp at the bottom. According to that paper, my entire farm, all 3,500 acres, had been sold at auction by the HOA for non-compliance. No warnings. No notices. No fines. Just gone. I drove straight to the courthouse, heart pounding, certain there had been a clerical mistake. The clerk didn't even look surprised. She pulled the file and slid it across the counter. There it was, a recorded deed transfer, signed, notarized, and approved. The seller listed was the HOA. The buyer was an LLC I'd never heard of. My name appeared nowhere. The clerk shrugged and said, on paper, it's legal. That sentence hit harder than any threat ever could. I requested copies of everything and drove home in silence, staring at land my family had worked for generations, now supposedly belonging to strangers because of ink and stamps. By the end of the week, more details surfaced, and none of them made sense. The HOA claimed my farm was annexed into their jurisdiction years ago, despite never paying $1 in dues, never receiving a letter, and never agreeing to a single rule. Their auction notice was allegedly mailed to an address that didn't exist. The vote approving the sale listed members who had moved away or died. And the LLC that bought the land? Newly formed. No website. No office. Just a registered agent 3 counties over. When I confronted the HOA board, the president smiled thinly and said, "You should have read the covenants." That was the moment I stopped panicking and started documenting. I hired a land use attorney the same day. We pulled original deeds dating back nearly a century, mineral reservations, boundary surveys, and tax records that proved continuous ownership. My lawyer didn't interrupt while I explained. He just flipped pages faster and faster. Finally, he leaned back and said, "They didn't just overreach. They committed fraud." But he also warned me, undoing a recorded sale would take time. Meanwhile, the buyer could claim possession. 2 days later, a letter arrived from the LLC's attorney demanding I vacate the property within 30 days. They cited trespass. On my own farm. I stood on the porch at sunset, watching cattle move across land my family had protected through droughts, recessions, and storms, and realized the HOA hadn't just crossed a line. They'd triggered something far bigger than they understood. Because buried deep in those old deeds was a clause no one had read in decades. And once it was activated, every house in that HOA would be at risk. The first thing my attorney did was request everything. Not summaries. Not explanations. Every document the HOA used to justify the sale of my farm. Meeting minutes, voting records, mailing logs, annexation maps, covenant amendments. Boxes of paper started arriving within days, and every page told a different version of the same lie. Dates didn't line up. Signatures repeated in identical ink strokes. Notices were allegedly mailed on federal holidays. One certified letter was marked delivered to a rural route number that had never existed. It wasn't sloppy, it was intentional. What caught our attention fastest was the annexation claim. The HOA insisted my land had been absorbed into their jurisdiction years earlier during an expansion phase. But county maps showed the opposite. The development stopped miles short of my southern fence line. Even more damning, annexation under state law required written consent from the landowner. There was a consent form in the file, bearing my name, but the signature wasn't mine. My lawyer didn't hesitate. He sent it to a forensic examiner. 2 days later, the report came back, traced signature, copied from a decades-old tax document. Someone had literally practiced my name until it looked passable. Then we followed the money. The auction records listed the winning bidder as a quiet LLC formed less than 3 weeks before the sale. We subpoenaed bank records tied to the earnest money deposit. The transfer didn't come from an investor or a development firm. It came from a personal account belonging to the HOA president's cousin. Same last name. Same hometown. The LLC was a shell, and everyone involved knew it. The farm hadn't been sold to an outsider. It had been taken and parked until they figured out how to profit. When confronted with these findings in a formal demand letter, the HOA's tone shifted from smug to defensive. They claimed it was all a misunderstanding, blamed a third-party management company, and offered to negotiate a settlement if I agreed to waive damages. That's when my attorney found the document that made him go completely silent. Tucked into the original deed from nearly 70 years ago was a reversionary clause written in dense, old-fashioned language. It stated that any illegal or unauthorized transfer of the land triggered automatic remedies, including financial liability for any party that benefited from the transfer, directly or indirectly. The clause went further. It allowed the landowner, upon court verification of fraud, to pursue equitable liens against properties tied to the benefiting organization until damages were satisfied. My lawyer read it twice, then smiled. They thought this was just land, he said. They didn't realize it's a trap. We filed an emergency motion the same afternoon, attaching the forensic report, banking records, and historical deed language. The judge didn't rule immediately, but he froze all further development activity and ordered the HOA to preserve assets. That order sent shockwaves through the neighborhood. Construction halted. Banks began asking questions. Title companies flagged transactions. Homeowners, who had no idea their board had sold a farm they'd never seen, started calling the HOA nonstop. The president stopped answering emails. Meanwhile, the Shell LLC quietly tried to dissolve itself, too late to escape the paper trail. As we prepared for the next hearing, my attorney laid out what came next. Once the court confirmed fraud, those reversionary rights would activate. And when they did, every home connected to that HOA would be pulled into the fight, whether the owners liked it or not. The hearing was scheduled for a Tuesday morning, and by the time we arrived, the courtroom was already full. HOA board members sat together on one side, whispering, pretending not to notice the stack of binders my attorney rolled in on a cart. The judge wasted no time. She opened by summarizing the evidence submitted so far, *** forged signatures, fabricated notices, and a shell buyer tied directly to the HOA president's family ***, and asked a single question: why should this court believe this was an accident? No one answered. The silence told her everything she needed to know. My attorney then introduced the reversionary clause. He explained it slowly, almost gently, like delivering bad news to someone who didn't yet understand the damage was irreversible. The clause wasn't punishment, it was protection, written generations ago when land fraud was common and courts were slow. It said that if the land were ever transferred illegally, the law itself would unwind the transaction and impose liability on anyone who benefited, including governing bodies that enabled it. The judge leaned forward when she heard that. She asked for the original deed. When it was placed in her hands, she flipped to the page and nodded once. The HOA's lawyer tried to argue that even if fraud occurred, individual homeowners couldn't be touched, that they were innocent parties. The judge shut that down immediately. Innocence doesn't erase benefit, she said. She ruled that the sale of my farm was prima facie fraudulent and therefore void pending final judgment. But she didn't stop there. Citing the clause, she authorized temporary equitable liens to secure damages during the litigation. Those liens would attach not just to HOA funds, but to every property governed by the association. Gasps rippled through the courtroom. The board members went pale. Within 48 hours, the effects were everywhere. Title companies flagged every home in the HOA as encumbered. Refinances were frozen. Sales collapsed overnight. Banks issued default warnings, not because homeowners had missed payments, but because their collateral was suddenly tied up in a massive fraud case. The HOA tried to calm residents with an email claiming it was a routine legal dispute. No one believed it. People started reading the court order for themselves, and panic spread faster than the board could contain it. Then the arrests began. County investigators, already alerted by the forged documents, executed warrants on the HOA offices and the president's home. Computers were seized. Financial records were pulled. The Shell LLC's bank accounts were frozen. By the end of the week, the HOA president and treasurer were charged with conspiracy, fraud, and falsifying public records. News vans parked outside the subdivision's entrance sign, the same sign that once bragged about exclusive living. Homeowners stood in their driveways, watching their property values evaporate in real time. My attorney called it legal gravity. Once the trap was sprung, everything collapsed inward. The court scheduled an expedited damages hearing and made it clear the liens would remain in place until restitution was paid in full, not just to me, but to cover investigative costs and penalties. The HOA had nowhere near the money required. That's when the board realized the truth they'd been avoiding. The only assets left to satisfy the judgment were the homes themselves. And the people who never questioned their HOA's power were about to learn just how far that power could reach, and how brutally it could turn on them. By the time the damages hearing began, the HOA no longer resembled an organization. It looked like a crime scene. The board had resigned en masse, the management company terminated its contract overnight, and homeowners packed the courtroom in stunned silence. Many of them were seeing the full scope of the fraud for the first time. Bank representatives sat in the back rows, legal pads out, whispering urgently to one another. Everyone understood the same thing. This wasn't about a farm anymore. It was about who was going to absorb the financial blast radius. The judge laid it out without drama. The illegal sale of my land had caused measurable harm, lost use, legal costs, reputational damage, and interference with mineral and grazing leases. On top of that were statutory penalties for fraud and falsified public records. The total damages were staggering, far beyond anything the HOA's insurance or reserve funds could cover. The court ruled that restitution had to be satisfied under the reversionary clause already affirmed. That meant the liens stayed. And if they stayed, foreclosure proceedings were not just possible, they were inevitable. Banks moved first. Several issued formal demands requiring the HOA to cure the title defects immediately or face accelerated actions. That was impossible. The HOA had no funds left, no leadership, and no credibility. Homeowners began turning on one another, some demanding the association dissolve instantly, others begging the court to exempt primary residences. The judge denied those requests. "This court cannot pick favorites," she said. "The law applies evenly, even when the outcome is painful." Her ruling sent a clear message: the consequences of corruption don't stop with the people who commit it. Within weeks, court-appointed receivers took control of the HOA's assets. Properties with the highest equity were targeted first. Notices of forced sale went out, and panic became reality. Some homeowners scrambled to settle privately, negotiating lump sum payments to remove liens from their properties. Others couldn't. For them, the process moved forward without mercy. Auction dates were scheduled. Sale signs appeared like warning flags throughout the neighborhood. What had once been a pristine development turned into a silent grid of uncertainty. The media framed it as a tragedy. Homeowners giving tearful interviews, claiming they'd done nothing wrong. But the court record told a different story. HOA members had voted year after year to expand authority, increase enforcement power, and silence dissent. They'd trusted a board that promised control without consequence. Now the system they supported was dismantling them piece by piece. Every auctioned house reduced the outstanding judgment, and every reduction brought the case closer to its end. I watched it all from a distance. The farm was already back in my possession by court order, fences repaired and cattle returned to their usual grazing routes. But the case wasn't over, not yet. The final phase was coming, and it would determine whether the HOA survived at all. As my attorney prepared the closing filings, he said something that stuck with me: they thought they were untouchable because they were organized. They forgot the law organizes consequences too. The next ruling would decide whether this HOA limped forward or vanished completely. The final ruling came on a gray morning, delivered without ceremony. The judge dissolved the HOA in its entirety, citing systemic fraud, abuse of authority, and irreparable harm to both members and non-members. Every covenant, fine schedule, and enforcement mechanism vanished with a single order. What remained were the consequences, unavoidable, already in motion. The court confirmed the farm's title fully restored to me, affirmed the damages judgment, and authorized the completion of all pending sales until restitution was satisfied. There would be no rewrites, no appeals that could stop it. The law had spoken, and it was done listening. One by one, the houses went. Some were sold quietly to investors, others to families willing to take the risk once the liens were cleared. A few long-time residents managed to save their homes by pooling resources, paying settlements that hurt but didn't destroy them. Many weren't so lucky. Entire blocks changed hands in months. The neighborhood that once boasted exclusivity became a cautionary tale, its entrance sign eventually removed because there was no association left to maintain it. The irony wasn't lost on anyone. The HOA that tried to control land it never owned couldn't even hold onto the land beneath its own houses. Criminal cases moved faster once the civil matter closed. The former HOA president accepted a plea deal that included prison time, restitution, and a lifetime ban from serving on any board. The treasurer followed. Investigators confirmed what we already knew, that the farm sale was never about rules or compliance. It was about opportunity. They saw acreage, assumed isolation meant vulnerability, and believed paperwork could replace ownership. They were wrong. Fraud leaves fingerprints, and the law is patient enough to find them. Life on the farm returned to something like normal. Leases were renewed. Mineral rights secured. The old oak near the creek, where my grandfather used to sit and plan planting seasons, still stood, untouched by all the chaos. I didn't feel victorious in the way people imagine. What I felt was resolved. The system had worked, not quickly, not gently, but completely. The land was safe, and the precedent was set. No organization, no matter how loud or organized, can steal what it doesn't own. The story spread far beyond the county. Other HOAs quietly revised their bylaws. Landowners pulled old deeds from drawers and safes, rereading clauses written by ancestors who understood something modern boards often forget, that power without restraint eventually collapses under its own weight. As for me, I kept farming. I kept paying taxes. And every time I passed the old subdivision road, now just another public street, I was reminded of a simple truth they learned too late. They tried to steal dirt, and lost everything built on it.